The state of Ohio is suing Alejandro Mayorkas. Federal law dictates that the privilege of participating in U.S. elections is reserved for U.S. citizens. If the state asks for it, Homeland has to give it to it. Homeland said, we're not offering you any alternative process. You're not checking anything, okay? Homeland has left us with no choice but to sue the state of Ohio and the Ohio Secretary of State. So an actual Secretary of State who's doing his job, unlike Jocelyn Benson, is suing Alejandro Mayorkas, Department of Homeland Security Secretary, and DHS themselves, saying that you guys are not helping us do our job, and you're mandated to do that under federal law. You'll see it's a 19-pager filed out of the Southern District of Ohio, the Western Division. Ohio and LaRose suing Alejandro. They say, all right, listen up, Alejandro. All right, look, federal law dictates, it mandates that the privilege of participating in U.S. elections is reserved for U.S. citizens, okay? And it's a crime for non-citizens to register to vote or to vote in federal elections, unless you're in Virginia and the DOJ sues you and a federal judge named Patricia decide that you can be a non-citizen, declare yourself a non-citizen, and get a ballot and vote anyways, because this is America suddenly. The Ohio Constitution provides only a citizen of the United States shall be permitted to vote at any state or local election that's held in the state. Now, the Ohio state indisputably has a compelling interest in maintaining their elections and ensuring that every citizen has the right and the opportunity to vote. But Congress now has provided a means to fulfill these duties. Ohio needs some help. By expressly compelling, Congress has mandated that Homeland and Alejandro comply with state requests to verify immigration and citizenship status. So if the state wants to know if somebody's validly here legally or if they're a citizen, the congressional mandate says that Homeland, quote, shall respond to an inquiry seeking to verify citizenship by providing the verification and status information. It's 18 U.S. Code section 1373 subsection C. If the state asks for it, Homeland has to give it to them. It's in the law. Now, the statute refers to the Immigration and Naturalization Service, but Congress has now transferred those duties to Homeland. Now, this obligation is so important and so non-discretionary that Congress also expressly outlawed any interference, even by other federal officials, with the prompt provision of immigration information to state officials, saying a federal, state, or local government, quote, may not prohibit in any way or restrict in any way anyone from the government from sending information about the status of an individual. And yet another statute also emphasizes this. It says, Title 8 U.S. Code section 1644 says here, notwithstanding any other provision of federal, state, or local law, no state or local government entity may be prohibited in any way from sending this information that is requested. The Supreme Court has said the same thing in Chamber of Commerce and Arizona. And Secretary LaRose has been relying on all of that precedent and has repeatedly invoked the statutory right for Homeland to make available to LaRose information allowing him, the Secretary of Ohio, to actually confirm the status of these people. Now, Ohio has access to DHS's Homeland system. It's called the SAVE program. It's called the Systematic Alien and Verification for Entitlements program, called SAVE. We're going to check. But SAVE is insufficient for this. You're kidding. For verifying citizenship status for most voters, because SAVE doesn't contain any driver's license number or social security numbers. The only way to identify someone in SAVE is to have one of a handful of specific immigration ID numbers, like alien registration numbers, that Ohio is rarely going to have. And so at this time, it is known to Ohio's secretary that there are individuals who registered to vote in Ohio despite previously telling Ohio that they're not citizens and whose citizenship status cannot be confirmed via SAVE, but they are registered to vote. Now, many of those individuals may have become citizens in the meantime, but Ohio is simply unable to confirm this one way or another. And so accordingly, on July 19th, the Ohio secretary sent a request over to Alejandro. They said, hey, Alejandro, can we access your federal databases and search tools? In particular, we need to access the PCQS, which is the Person-Centric Query Service, to ensure that Ohio could verify the citizenship of specific registered voters whose citizenship may be the subject of dispute. We can check that database. Sounds better than SAVE. This one draws from a much broader array of ID information, making it far easier for state officials to confirm the status without having to use one of these immigration identifiers, which we rarely have. Now, Secretary LaRose asked Homeland to respond, asking them, what is your intention to comply with this request? Okay, we have an election coming up. It is imminent, and we need to know answers to this because We need to get these people off the rolls. So, but July 26 came and went. He said, can you please respond quickly? He sent this letter July 19th, said, can you respond like in 5 days? We've got an election coming up immediately. But of course, Homeland's like, just say we're out of town. So Secretary again contacted Alejandro on July 30th. He said, hey, we want to check citizenship status with your people. Now, even after a month of silence, then they contacted them a third time, August 29th. And they say, hey, you've got a mandatory obligation to help us with this. This request expanded the original request. And they said, all right, look, now we want access to this system too. The Central Index System and the Person-Centric Identity Services, PCIS, that database too. We want any other system as well. And still, Homeland gave no response at all. So then they sent a fourth request on September 11th. And that finally elicited an acknowledgement, an email stating the original request had been received from July in September. They're like, oh yeah, we got the first one. Sorry, we were out of town. And as a courtesy, they sent it to another office within the DHS bureaucracy for a response. Yeah, let me send that over to the archives division. We'll see what they say. Homeland identified yet another office that the secretary should send this info to for the most direct and timely response. We're like, just forward it over to their office. He's out of town, forward it to him. So then LaRose resubmitted its request less than an hour. They said, okay, that's the right division. Poof, here's my request again. Here it is again. Again, no response came. So then Representative Jim Jordan came in. He is the congressman from Ohio, and he's the chairman of the Judiciary Committee. Then he sent a letter to Alejandro, who has asking why he hasn't responded. Then Alejandro threw his in the trash too, because what's Jim gonna do? On October 10th, nearly 3 months after first requesting assistance, then LaRose, it's October now, right? The election's like right around the corner, and like, oh, sorry, it's too late to do anything. Delay. Then it's too late to actually remove anybody because it's too close to the election, and we know that's a due process problem. So then he finally got a response from Homeland. The letter claimed, no, you don't need access to anything, okay? Be quiet. Here, this is sufficient. Save is fine. Despite Ohio's previous letter saying, we don't have the ID numbers because we're not federal government. Now, despite its statutory duty to provide citizenship, Homeland said, we're not offering you any alternative process. You're not checking anything, okay? Because PCQS would require a manual review of the results. And they said, well, we'll do it. The Secretary of State in Ohio said, that's fine. That's okay. We'll check it. If there's anything that conflicts with the other systems, we'll check it. No problem. We'll do it. Don't worry about it. So then on October 14th, Ohio, through its Attorney General and joined by 15 other state AGs, they sent a letter to Mayorkas expressing concern about the delayed and inadequate response. They say, you've got an obligation to execute your duty. The state AG requested that Homeland provide them with their plan to respond. But guess what? To this date, at the end of October, elections right around the corner, Homeland has not responded as they're obligated to do. And so by declining to provide citizenship and by further stating that it's going to refuse to give us access, Homeland is violating the law. It is required by law to respond to an inquiry from us. And as a result, we are unable to verify these citizens and their status. And so by ignoring these requests for months intentionally, right? Delay. Homeland has left us with no choice but to sue, to get information that's already been mandated by Congress, already been mandated under the law. The court should grant an injunction and or a writ of mandamus to order them to immediately give us this information so that we can do our jobs. We know who the parties are. We know where the courts are. They give us some more details on this. Congress created a mandatory duty and went even further by saying you cannot prohibit our access to this. We sent multiple letters, 3 of them, 4 of them, invoking this statutory right, and Homeland is refusing to do it. Their letter in October is conclusive evidence that they're literally violating, and they intend to continue to violate, the law. 8 U.S. Code 1373 says they've got to do it, and they haven't done it. We've already explained why SAVE is terrible and insufficient. We don't have the numbers that they say we should use because they don't give us the numbers because we're the state government, not the federal government. It requires a unique immigration identifier, but we don't ever have that. SAVE does not allow for searching based on a name, on date of birth, on the last 4 digits of a social. You can't even search for a name. Here, use this search engine. What do I put into it? A number. Well, what number? An immigration number. Whoa, can we have them? No. Okay. Well, how are we supposed to use the search engine? Figure it out. The Ohio Secretary of State also found even when a unique immigration identifier is available, SAVE is still sometimes inconclusive because the naturalization records aren't even linked. It's just like, well, check it over here. It's like, why don't you use Alta Vista? Here, it's like using Alta Vista to find something in 2024. Remember that search engine? Now, these limitations leave plaintiffs unable to confirm confirm that certain individuals are actually citizens, as required by federal law. At this time, there are individuals who've registered. We know. We're trying to resolve these. We're trying to figure this out. We've asked Homeland to give us access so we can actually verify their citizenship using, things like a name, like a date of birth, for crying out loud. But defendants have refused access. They say, no, it's not an option for you. Sorry. Because it would require manual review of the results. Sorry. On the results in each case to determine immigration status. The potential need for manual review does not excuse them. I don't care if it's manual. We'll do it. No problem. Although defendants have a non-discretionary obligation, so they can't choose not to do this. They have now formally refused to do it, and they've done it in writing and sent it back to us in a letter that they're not going to give us access to this. So they are now in violation of the law. They're violating and unreasonably delaying access to these materials. And we have met the standards to have an injunction here. They have a statutory obligation. They formally refuse to do this. We have a compelling interest in protecting our elections and stopping non-citizens from voting. The harm is imminent. We have an upcoming federal election less than 2 weeks away, even sooner now. And this information is needed to verify this. Now, they have delayed this for months unnecessarily and caused this problem. They did it obviously intentionally. They had a statutory obligation, but they delayed so that they could have illegals voting in the elections. Now, they also have said that we've exhausted all other avenues of relief. Okay, we've sent multiple letters. We need you to step in court and mandate them to do this because they're not complying with us. We've sent letter after letter after letter. The law requires them to respond, but they are not responding. And so their decision to limit their responses is not in accordance with the law. And so we also want a declaration that they are in violation of the law and that they shall respond to our next inquiry. Save doesn't work, and so we need access, and that they must respond in future requests. So we want all of those things. In sum, we also want attorney's fees for making us go through this to enforce the government to do their jobs. Signed here by councils for Ohio, the state of Ohio, and the Ohio Secretary of State. So that's what an actual good secretary is doing to ensure the integrity of their elections.